I've been practicing, I'm in my 9th year now. And that's about it for just a brief intro, I guess.
And I'm Ginger Sheehan, and I'm a partner here at Orr Reno, and I've been practicing for much longer than that. I'll just say that. So Andrea's gonna take the lead on this, and I will pipe in as I feel like, or if she needs me to.
Yeah.
And kick it off.
So today we're just going to be talking about estate planning basics. So like the title, it is going to be fairly basic. So hopefully, if you already have some experience with estate planning, it won't be too boring for you.
And feel free to ask questions at any time.
Yes, please.
Just stop us and ask questions.
So the topics we're going to hit on today are what is an estate, what is probate and how to avoid it, what happens when you don't have a will, what is a trust, how to protect minor children, and what happens if you become incapacitated during your lifetime. So what is an estate? An estate is essentially everything you own. It's all of your assets. It's your whole big estate. That can include real estate, bank accounts, non-retirement investment accounts, life insurance, retirement benefits, vehicles, antiques and collectibles, and any other personal belongings. And you own more than you think. I have a lot of clients that come to me and they say, I don't really have very much. But when you actually look at this list and any other assets that they might have beyond that, they actually do have quite a bit. It all adds up. And your estate plan is more complex than you think as well. A lot of my clients come to me and say, this is very, very, very simple. It's very simple. And then when we delve into it, they learn that it's actually not as simple as they thought. So what is probate? Probate is court supervised estate administration of all of the assets that you own in your individual name at the time of your death. So these assets are not jointly owned, they're not owned by your trust, and they do not have a beneficiary designated who is alive at the time of your death. Probate is a public process, so anybody can access the filings that were filed with the probate court in your case, so they can see who the beneficiaries are, what their addresses are, what the assets value is in the estate, and basically who's getting what. So it's very, very public, and there's really no hiding any sort of that personal information. Probate also requires a filing fee to initiate the probate action. The executor administrator might be required to pay a bond premium. They might have to get an insurance bond to make sure they're not going to run off with all the money or the assets. Probate can be quite complicated. Usually the executor or the administrator needs to hire an attorney to help them through the process. In New Hampshire, probate lasts a minimum of 6 months from the date that the executor or the administrator was appointed by the probate court. Usually it lasts more like a year or longer until all the assets are able to be distributed to the beneficiaries. Probate can also be stressful, and it's very time consuming on the executor or the administrator. And your estate goes through probate whether you have a will or not. Anything you want to add on that?
No, just the only other thing on time consuming is the courts are constantly backed up. They're underfunded, they're understaffed. Sometimes it can take 3 months to get an appointment.
Yeah.
And then you have to wait that 6 months from that date forward for the estate to be open. So it's not just gathering assets and things that could be time consuming. It's the courts are very, very slow sometimes.
Yeah.
Most of the time.
Yeah, a lot of times it's kind of just a hurry up and wait. So you do a lot of work in the beginning and then you wait 5 or 6 months until you can take the final action. And if you have any questions, feel free to raise your hand or just shout out to us. All right, so what happens when you don't have a will? When you don't have a will, your estate will go through probate. So all of your assets that you own in your individual name will have to go through the entire probate process. The probate court decides who will raise your minor children. So that'll be based on who steps forward and petitions the probate court to become the guardian of your minor children, if any. There might not be anybody that steps forward to do that. And in that case, a public guardian would be appointed for them.
And what we tell people is even if you don't know, and I've had relatives who never did this, and thankfully their children made it past 18, because they couldn't decide who to name. And I always say, the most important thing is to at least put somebody in there, so you're excluding the people you don't want. And you can also say who you don't want to ever raise your children. And that's exceedingly important, and you can change it. So after Thanksgiving, when you're mad at these people, you can change it to somebody else. So it's appointing a guardian is probably one of the most important reasons to have a will for young children.
Absolutely. And kind of in that same vein, the probate court also would decide who's going to administer your estate, because you don't have a will that names your executor. So kind of along the same lines, if nobody steps forward to administer your estate and ultimately distribute your assets, nothing will happen with your assets.
They're just gonna appoint an attorney or somebody.
Would they, or would it go
Yeah.
to state?
No, the court would appoint an attorney.
Okay,
And there's certain people that would do that, but they don't know your family, they don't know your assets. It's a really,
not ideal.
it's a intrusion, really, a big intrusion on
Yeah.
privacy and everything else.
You also don't control who gets your assets after you pass away. So when you pass away, your assets are going to be distributed pursuant to the state that you were a resident of when you passed away. Pursuant to it's called the intestacy statute. It's a statute that basically says this is who gets your assets in what order if you die without a will. For example, in New Hampshire, if the decedent, otherwise known as the person who's passed away, was married, his spouse might receive some or all of the assets. If the decedent had children, his children may receive some of the assets, but they might not get anything in some situations. But stepchildren, friends, supported charities, siblings, nieces and nephews, they're not entitled to any of the assets under any state's intestacy statute that I'm aware of.
Unless there's nobody else. We have nieces and nephews on there. Yeah, it's not on the slide, but nieces and nephews could. So relatives, there's just a flow chart, but if somebody dies with no children, no spouse, no grandchildren, so nobody, no lineal descendants, I always think of it, it goes up to parents, and if they're not alive, out to siblings, down to their children. So, and it can be really hard to find those people. We've had to do that before, so that's another, and so we always, another thing to be talking to people who don't have a will, just say the lawyers are gonna get all the money. That usually is a motivator to get people to do something, because it's true, it's really hard to find people if we don't know where they are. You have to go searching for them.
What happens when you do have a will? So when you have a will, your assets still have to go through the probate process. But the benefit is that your will states who's going to get your assets after you pass away. So in that instance, you could give your assets to friends, non-blood relatives, charities, siblings or nieces or nephews. You can also designate a guardian over your minor children, which we kind of talked about already. That's, as Ginger had stated, probably the most important reason that a person would do a will that has minor children, is so they can designate a guardian for their minors if something were to happen to them before their children turn 18. You'll also name an executor to be responsible for administering your assets. So you can choose who you want that person to be, somebody that knows your family, that will be able to properly interact with everybody else that's involved. In a will, you can provide a trust for your minor children or others that might be minors when they're going to be receiving their assets. And that's also called a testamentary trust, but that's going to be subject to court supervision during the duration of the trust. So if the minor child is 2 years old when you pass away, you've established a trust through your will, this testamentary trust, there's going to be probate court oversight for the next 19 years, which is going to be very expensive. Not economical at all. But without a testamentary trust, your beneficiaries would receive everything at the age of 21. And I guess I should reiterate, or with a testamentary trust, you can establish a trust for your beneficiaries, and they don't have to get it at age 21. They can get it at a later age. Whereas if you haven't established this testamentary trust, they would receive everything at the age of 18 or 21.
Yeah, and testamentary trusts are the worst part of probate. that and regular guardianships of adults, which can't be avoided sometimes, but you do not want this for anybody. So if you have grandparents or anybody you know that says, I'm just gonna leave your children, you know, a little bit of money, just make sure that there's ways to do it where in a will, even if they don't have a trust, where you can avoid a guardianship. There's statutory ways to do it and, but you just need to consult with somebody and find out how to do it.
Which brings us to what is a trust? So we kind of touched on what a testamentary trust is. So that's a trust that you make through your will that is subject to probate court supervision until the trust terminates. Most attorneys these days don't draft testamentary trusts anymore, just because they are super uneconomical and they just don't make sense with the other options that are out there. And we generally don't recommend doing a testamentary trust either. The other type of trust is called an inter vivos trust, or a trust that you make during your life. So that's the most common type of trust that people do, is they'll establish their own trust while they're alive. And that's usually either a revocable trust or an irrevocable trust. A revocable trust is generally part of your overall estate planning. And an irrevocable trust is kind of an addition to your general estate planning. With revocable trusts, you maintain control over all of the assets that are in your trust. They're much more flexible than irrevocable trusts, but they don't provide any sort of creditor protection or protection from a divorcing spouse or anything like that. Whereas irrevocable trusts can be drafted to provide asset protection or protection if you have to go into a nursing home or something in the future. There's all sorts of different ways people can draft irrevocable trusts, but they're not as flexible as revocable trusts. And the grantor or the creator of the trust doesn't usually maintain any sort of control over the assets that are in that irrevocable trust, or the ability to change the trust at a future date.
And we used to do a lot more irrevocable trusts for tax planning purposes, for federal gift and estate tax planning purposes. The federal estate tax exemption is very, very high now, so we don't do as many of those. But another really good purpose of a irrevocable trust is you can make completed gifts to that trust and get them out of your estate. And that's another reason why the grantor can't be the trustee and can't have control. So that's a constant conversation with clients because they want to give away their assets, but keep total control over their assets, which is just kind of human nature. There's ways to keep some kind of control, but not a lot.
Yeah. So with the trust, all the assets that are owned by that trust will avoid probate when you pass away. So I usually like to explain it to my clients where once you sign your trust document, you start off with an empty bowl. And what you want to do is you want to put your assets into the bowl. And you do that by retitling any assets that have any sort of certificate of title or ownership. So for example, with your vehicles, you would want to go to your local town hall in New Hampshire at least and re-register and retitle your vehicles to your trust. Same goes with your real estate. You would do a brand new deed, which transfers your real estate to your trust. And any other asset that has any sort of certificate of title or ownership, you want to make sure you retitle that asset to your trust. And that's how those assets will avoid probate when you pass away. Like we briefly touched on with the revocable trust, you maintain control over the assets and who receives them and when, so long as you're alive and you're competent. And once you pass away, your successor trustee has almost immediate access to the assets in the trust and can start making distributions to the beneficiaries if it's appropriate. Versus with the probate process, they're gonna have to wait a minimum of 6 months, if not a year or more, in order to be able to make the final distributions of the assets to the beneficiaries. And like Ginger had touched on, you can possibly reduce federal estate tax with certain trust planning as well. And you can provide for special needs beneficiaries through special needs provisions in your trust or with a special needs trust altogether.
I'm just going to make a couple comments. So sometimes when we send clients out with instructions to retitle their assets, a brokerage account, for instance, in the name of their trust, like Bob Anderson, trustee of the Bob Anderson Trust of 2024, whatever the name of the trust is, They are told by their financial person or the bank, oh, just put a TOD on. And name your trust as the beneficiary. A TOD is a transfer on death designation. It's like a beneficiary designation on an IRA or a life insurance policy. And for a while, this was all the rage, and we kept hearing this and hearing this. It is not the same thing. Do not do that. And if you have clients, do not tell them to do that if you're asset manager or whatever. Retitle the assets. We've run into problems in the past with TODs where sometimes the probate courts who are unpredictable will say, I had this happen once. You have to have your executor appointed to direct, Fidelity told us this. It wasn't the probate court here. Fidelity told us you have to have an executor appointed, even though there were no probate assets, because TODs go outside of probate. You have to have an executor appointed to direct us to distribute the assets under the TOD. You just don't know what's out there. The financial institutions throw things at us constantly. You just don't know. Retitle the assets. Do not use TODs if you can avoid them. Sometimes they're appropriate, but usually it's better to actually retitle. Then you just have your bowl. You change the governing document for that bowl, and then everything goes pursuant to those terms. The other thing I was going to point out is testamentary trusts. We do not use them in New Hampshire, as you can tell. Other states do. So if you have somebody who brings you some trust from New York or something, you may see a testamentary trust. I think it's all a mystery to us what goes on in New York, but in California and places like that. But sometimes you're going to see testamentary trusts from those states because they have unsupervised probate. It's not such a cumbersome process. California is a community property state. They have totally different laws for division of property between spouses. So I think they use a lot more testamentary trusts and joint trusts. So I just wanted to point that out too. You may see them coming in on documents from other states if you're those documents.
And I actually recently had a client come my way. Her 18-year-old grandson, whose father just passed away, had set up a bank account for him with a TOD to grandson. And after several attempts, the bank still wouldn't allow him to gain access to the money in that account, even though it was a proper TOD designation. So it's not just like brokerage institutions, it's general banks as well. So if you can avoid doing a TOD and you can retitle the asset to your trust, that is the best option.
That's
Yeah.
I have a client that set up a revocable trust in New Hampshire. He moved to New York. He died in New York. So then we had New York as the state. And in that trust, he wants another trust, a family trust. Does the family trust have to be New York or can it be New Hampshire?
For the governing law, well, there's two issues there. One is the governing law of the trust. The other is the place of administration of the trust.
Right.
So
Yeah.
that's a good question. Usually the governing law will still be under New Hampshire law unless there's something under New York law that allows you to change the governing law. You can change the place of administration, which affects income tax, whether it's taxed in New York.
Right.
So New York will probably grab that trust to tax it.
Right.
They're all very
That's
good
what
at
I'm
that.
afraid of.
Yeah.
So I know that was what we were thinking, could we say, well, the administration is New Hampshire, but
Where's the trustee located?
in New York.
Yeah.
Yeah.
Kind of sunk.
Right.
Yeah, and what you look at is the requirements for a resident and a non-resident trust for New York income tax purposes.
Right.
And
Now
that,
she's moved to Jersey.
but to make it even more
Yeah,
complicated.
right. But we were figuring we were gonna have to go with New York,
Probably.
because the main trust, the administrative trust is New York. So we figured the family trust will have to probably be New York
Right,
also.
it would follow unless the
Yeah.
trustees change. Like sometimes you can get out from underneath that state
Right.
income tax if the trustees are out
Gotcha.
together.
Okay.
Other times you can't. You just got to check those resident and non-resident.
Yeah, New York's very aggressive. I'm from New
Yes.
York.
Yeah, you're very aggressive. Massachusetts is very aggressive.
Yes.
The states with state income tax are very aggressive. So you have to be
Thank
careful.
you.
Similarly, if somebody creates a will in New York and then moves up to New England, and just never update it. How does will and trust kind of have similar issues?
Yeah, if it's that's a really good question, because if somebody has a testamentary trust, for instance, in a state where testamentary trusts aren't really a problem, then they move here, that could be a big problem if it's for young children or something like that. So it's a really good reason why people have their documents updated. They are valid. All states have, reciprocity or, full faith and credit for anything, from another state that's valid in another state.
But then states might just take tax and fees and things if it switches through.
If it what?
If it switches like from state to state, whether it's valid or not, the issue is tax coming out and.
It's income tax, probate, actually probate. So what we do in that case is we have to have somebody in New York sort of fill out a form, and a local attorney saying the will was properly executed in New York under New York law, because we don't know that, and then New Hampshire courts don't know that. Then we file that with a court here, so then it's accepted here, and then it's subject to New Hampshire probate laws. And then the income tax issues are a whole other thing. You gotta figure
The mess.
So if you have clients that came from out of state,
Yeah.
definitely have them update their estate planning documents.
Okay.
You made an excellent case for avoiding transfer on death issues. A primary residence many times is joint ownership with rights of survival. Is that outside of this process, or does that again have to be legally designated for the surviving spouse? The issues there?
So when we're planning for spouses, for doing a joint planning, we take their residence into consideration. Most of our clients do revocable trusts, and will transfer the trust out of their joint names to their trust. So their trust is the owner of the property. So then, because what we're planning for is what happens when they both pass away. Because if they own it as joint tenants with rights of survivorship, then there's no worries upon the first spouse to die, because the survivor automatically becomes the owner, the 100% owner of that property.
Without having to go through a probate process?
Yep, same thing with joint bank accounts with spouses, and like they're joint on the title to their vehicles or anything like that. But what we're ultimately planning for is what happens after the second spouse passes. So by doing the trust ahead of time, we make sure that we have a plan in place for both spouses in the event that they pass away together. And also, if they never update their estate plan ever again, then we at least have a plan in place for what happens when they both pass away. And if their house is owned by their trust, it will not have to go through probate upon either of them passing.
Just a small segment of the population, if you transfer your home in primary residence into the trust, do you lose the veterans credit?
No, not to I've looked into it a couple years ago.
Yeah, you did.
I did.
Yeah.
Yeah, and I've had clients that have transferred, they were receiving the veterans credit. You're talking about for real estate taxes?
Yeah,
Yes.
$500 a year, whatever.
Yeah, and they've never come back to me and said they've had an issue with it.
They're basically an alter ego. And so we have, if we get a question like that, we just say, go to the town and tell them it's under your social security number. All the everything in the federal government doesn't care if you have a revocable trust. They never even want to know. Because all your 1099s come under your social security, everything that's on your income tax, your 1040.
I suppose it's a small number in the scheme of what we're talking about, but nevertheless, if somebody's
important.
younger.
Yeah, absolutely.
Exactly.
And it's important because those people that are receiving that credit, they need it, so you don't want them to lose it. Any other questions? How to protect your children with a trust. So oftentimes our clients that have minor children end up doing a revocable, we'll just say they usually do a revocable trust as part of their overall estate planning. And with that, they can give the trustee discretion as to when to distribute assets to their children. So usually how it's set up is they might give their trustee discretion to pay for anything that their children needs for their health, welfare, education, and for any other purpose. But they're not gonna get cash in hand until they turn 25, 30, and 35. So they're giving the trustee discretion to look at their children's lives, look at what they need, and pay for anything that their children need or give money directly to them if that's what's appropriate. And then also they have mandatory distributions at those ages 25, 30, and 35, for example. They can also establish a fully discretionary trust for their children, so there's no mandatory distributions that the trustee has to make. So this oftentimes is a trust that's established for the lifetime of the child. And the trustee has full discretion to make distributions for whatever purpose. But the fact that it's fully discretionary and there are no mandatory distributions makes that trust, what am I trying to say?
Creditor proof.
Creditor proof. Yeah, so there's a creditor protection component. So if they're sued, the creditor can't force distributions from the trust. If they're going through a divorce, the money in that, or the assets in that trust are not going to be part of the marital assets that can be divided. If the child has a disability, or if they're in a car accident or something in the future and they're just not able to financially manage money, the trustee will be able to pay for whatever they need. And if you have a child or a beneficiary that's just very irresponsible and they just spend everything that comes their way, this fully discretionary trust can be very beneficial for a child or a beneficiary who is just irresponsible.
We do fully discretionary trusts for, kind of the tragic situations too, where there's substance abuse issues and things like that. So if it's somebody else setting up a trust, if a parent sets up a trust for a child, and it's fully discretionary, they're pretty much bulletproof. You can set up a trust for yourself under certain conditions that have some creditor protection, but there's a whole bunch of rules to doing that. But if somebody else sets up a trust and puts their money for another person in a trust and says it's fully discretionary, that's a very, very protective trust.
I recently had a client come to me and one of their children was contemplating divorce. So they're like, what happens if we die while they're in the middle of their divorce? We don't want all the money to go to the husband. So we amended their trust because they already had one in place. And we set up a fully discretionary trust for this particular daughter to make sure that if something does happen to them while she's going through this process, that the money will be protected. And then once she's finished with the divorce, they can amend their trust if they want to, change it back, and get rid of the fully discretionary trust and redraft it to give the assets to her outright, if that's what they think would be appropriate at that time.
I've done that a number of times, and I usually suggest that they talk to the child, so it's not a shock. And if their sibling is going to be the trustee, that the child is okay with that. Because these fully discretionary trusts, if the siblings are not getting along, or the one sibling has a little power trip over the one who's got the discretionary trust because of this potential divorce, and nothing the one, this one over here is the beneficiary of the trust can do. So fully discretionary trust, there's a cost to everything. The cost is the beneficiary can't get anything. The benefit is neither can the beneficiary's creditors or a divorcing spouse. So we usually tell them, talk to your children so it's not a shock, and make sure they understand this. Yeah, if you die before this whole divorce thing is taken care of.
Yes. And you want to talk about special needs?
Well, I was just gonna say special needs, people with disabilities, these trusts work for that too, except what we always recommend, because government benefits are so complicated. We do not keep up on those, nor could we, and there are people that specialize. There are attorneys who specialize in special needs trusts and disability planning. And so we always, even though we're fairly confident one of these kind of discretionary trust would work, we always tell our clients, go talk to a special needs attorney and have that part of the plan. Because you can do a special needs trust too, which is another, it's a more, it actually has many more provisions in it that says basically that anything not covered by government benefits can be paid for by the child. So, or I'm paid for by the trust for the child or the beneficiary. So it's just kind of a subset. It's very complicated and certain people specialize in that. So we send our clients to those people if it's a serious special needs issue.
Like Medicaid planning too, we don't really dabble in that either.
We used to. It's so hard. We did it all the time, but it's just so hard to keep up on everything.
All right, what happens if I become incapacitated? So this is kind of, when I describe estate planning to people, I describe that we're planning for both what happens with their assets after they pass away, but also what happens with their assets and their healthcare decisions if they're alive, but they're unable to make those decisions for themselves. So as important as the will and the trust, in my opinion, is having a durable power of attorney for finances and a durable power of attorney for healthcare. These documents allow you to appoint an agent to step into your shoes to make financial or healthcare decisions for you in the event that you are alive, but you're incapacitated and you can't make those decisions for yourself. With the healthcare document, that's changed a couple years ago, drastically changed, actually. There used to be, if you've seen one, there used to be a bunch of end-of-life decisions that the client had to make. Now there's basically just one, and the agent, whoever your agent is, can make it pretty much any and all other medical decisions for you. So on the financial side, it's very important to have that power of attorney for finances as well, to make sure that you don't need to have a guardian appointed for you to manage those assets. Because that's expensive. It's a very expensive process, because both sides have to have an attorney representing their interests. And then moving forward, there's annual reports that have to be filed, and having a power of attorney just is a lot easier. And then if you have a trust and you become incapacitated, your successor trustee will manage the assets that are owned by your trust. Oftentimes, the successor trustee is the same as the agent under the power of attorney for finances, so they kind of work hand in hand.
And sometimes that, the power of attorney, somebody will come into us, their mother or whoever is incapacitated, we get a letter from the doctor, we release the power of attorney, and then we work with that child or that agent under the financial power of attorney to look at all the assets, how they're titled, and if everything isn't in the trust, the agent can finish up that process of making sure everything is titled in the trust, even after incapacity. So that's one of the things an agent can do, along with a broad additional authority.
My husband worked for the disabled in New York. And one thing that came up was many times the disabled lived at home and they had a healthcare proxy for resuscitation. They had to have one for in the home also, so that when they summoned emergency care, you could prove to the medics that it was do not resuscitate.
Interesting.
Yeah, which I was a nurse before and I never knew that. So they ran into that problem.
Yeah, my experience with do not resuscitate orders is just, from experience and I think it's a very practical thing too. Because paramedics rush in and they are supposed to save lives.
Right.
And so I have visited clients in very, bad medical situations. They've been through hell and the doctors have issued that DNR and said, you're eligible for that. And they said, I want that. And it's posted everywhere,
Yeah,
which is
Yeah.
a really good idea to do. But
I don't think a lot of people know that though,
yeah, I don't know. And I think we just hear from clients about what
Right,
happens,
what
but it is a really
yeah.
smart thing to do.
Right.
But your agent, that's a good thing to bring up because your agent can consent to that DNR. So
Right.
if it's time, the doctor says it's time, the agent can consent for you on that DNR. So the other thing we tell our clients is talk to make sure you're not appointing somebody that you haven't talked to.
Right.
And tell them your desires and tell them your intent and what you want at end of life or some kind of a healthcare emergency. That's a good point.
Yeah, and every state is different. I had someone come to me recently, and I think he had lived in Florida in the past, and he was asking me about like specific power of attorney for mental health. Because he said in Florida, or maybe it was Texas, that they had a financial power of attorney, just a regular one, and then they had a separate one that was specific for mental health. So every state has their own little, nuances, and every state is different. So another reason why it's very important to update your estate planning documents when you move to a different state.
And sometimes we actually do, where we have snowbirds, we say, have a set done under Florida law, have a set done here.
True.
It doesn't seem to be as much of an issue as it was maybe 20 years ago when these were new documents. Because the doctors and nurses and the medical staff were used to their state's forms, and if somebody comes in, they didn't want to have to send it to legal. I haven't heard as many problems lately, because I think it's just, okay, do you have one? What state's it from? But sometimes we do that as well, do a set, not the financial, just the medical, set in Florida or wherever they go, winter set here.
Or even if we have clients that regularly treat down in Boston, but they live in New Hampshire, we might do a Massachusetts healthcare proxy and also a New Hampshire advanced directive as well.
As I understand it, those are needed at age 18 and over. So if you have a
That's
child
correct.
going off to college, you don't have any rights
Right.
to intercede.
That's very correct. Yeah, and I've definitely talked about that in the past, and I've actually done that for a few of my clients. When their children turn 18, I've done advanced directive and power of attorney for healthcare or for finances for their child, because after I've explained to them, you won't be able to talk with their doctors, you won't be able to access their finances if you need to and help them pay their bills or whatever. And that's very scary because most parents are actively involved in their children's healthcare and managing their bank accounts. And then just to have that cut off when your child turns 18 is a shock, and most people don't realize that that's what's going to happen. So yeah, it's very important if you have clients that have children that are turning 18 to at least get a healthcare directive and financial power of attorney in place.
Should colleges have a copy of that?
I guess I think they usually have a process for allowing the parent to see, they can pay the bill, but in order to get a copy of the bill or whatever, I think there's something the student can do on campus. But
Yeah.
yeah, if it's necessary, then they can give it to the school, and they can also give the school a copy, the health center or however that happens, a copy of the healthcare power of attorney. But it is a shock. I've gone through that, and all of a sudden you're just completely cut off from. And so it's a really good idea. We do that for quite a few of our clients, but
Yeah. Because even an 18-year-old, when they're gonna go to their doctor's appointment, usually their mom's been going with them their whole life, but now they have to go alone. Hit on everything here. So who needs an estate plan? It's very broad, but everybody. Everybody needs some sort of estate planning. And you kind of just hit on the topic for younger children, having the power of attorneys. But, do you want to say something? No. Oh. When you're older, you've had plenty of time to accumulate assets, and you generally have an idea of who you want to receive those assets when you pass away. When you have young children, as we've talked about, you want to make sure that you are the one who is in charge of determining who's going to be the guardian and who's going to be managing the assets for the benefit of your minor children. If you have children from a prior relationship, you can make sure that they receive some of your assets. And I think this might be on a later slide, but I've had clients come to me who have had children from prior relationships. They're now married. They want to do their estate planning, and there's specific planning that you have to do for couples in that situation, because they might accidentally disinherit their own children and give everything to their spouse if they pass away first. And they don't realize that that's a real possibility if they don't do proper planning. So it's incredibly important for people that have children from a prior relationship that are doing planning together to make sure that they're meeting with an attorney, they're talking about the issues, and making sure that they're putting a proper plan in place to make sure they don't disinherit their own children. Married couples still do need an estate plan, even if all of their assets are jointly held, and we kind of touched on this earlier. If everything is jointly held, when the first spouse passes away, usually nothing has to be done. In New Hampshire, there's one document that we file with the probate court, essentially putting the court on notice that the person has passed away, but there's no assets that have to go through probate. But what we're really planning for is what happens if they pass away together and what happens when the second spouse ultimately passes away. Because unfortunately, we cannot live forever, no matter how hard we try. It's very important for non-married life partners to do an estate plan as well. And the reason for that is under most state statutes, or at least under New Hampshire, there are specific provisions that allow a surviving spouse to be able to receive some of the assets of their deceased spouse's estate plan. But they have to have been legally married or be deemed to be common law spouses. So if you have clients that are not married and they don't plan to, or even if they do plan to, it's important for them to do some planning together to make sure that they're gonna be giving assets to each other in the appropriate way to ensure that their partner is not going to be disinherited if something were to happen to one of them. Single adults, young or old, also need to plan because everybody has something. Even if it's a bank account or a retirement account or vehicle, it's very important to be able to take control and be able to direct what happens with your assets. But as importantly, as we've discussed, is making sure that they have those advanced directives and the power of attorney for healthcare or for finances in place as well.
And an estate plan can be making sure your beneficiary designation for your IRA or your 401k is updated. I mean, a lot of people, their savings is primarily in their retirement accounts, right? And they pass by beneficiary designation. Those should be reviewed every few years to make sure they are up to date and to make sure that everything is proper on them, including, okay, I'm gonna leave my 401k to my 5 children, I don't have 5 children, but this is an example, 5 children, and I wanna make sure that, and all their children, my grandchildren are now now of age, and so I wanna make sure that that little per stirpes box is checked. So per stirpes means that if one of my children isn't living, it's gonna go to my grandchildren. If that box isn't checked and one of the 5 children dies, there are now 4 shares of that $1 million IRA. That happens more than you think. And you have to really look at those things. The beneficiary designations are unbelievably important. I've had and this is all to avoid litigation and to keep families together and to not cause a huge fracture through litigation when somebody dies. I've had a beneficiary designation where there were 2 lines for primary and there were 3 beneficiaries, 2 children from a prior marriage and the current spouse. And the decedent was advised, oh, just put the 3rd one on the next line, which was contingent beneficiary. Thanks. It was a huge mess. These things are incredibly important. The other big issue for IRA beneficiaries and retirement beneficiaries, life insurance as well, is to make sure nothing goes to a minor child, because otherwise you're going to end up with a guardianship. So you want to make sure it goes to them, either to a trust for them or under the Uniform Transfers to Minors Act, which is sometimes it's a box right there. We love institutions that give us beneficiary designation forms that have stirpes and have UTMA, Uniform Transfers to Minors Act. Check those little boxes. It's not going through probate. Everybody and their children get the proper amount, and you're going to avoid a guardianship for the minor children who it's going to go to them at 21, but still that's much better than having it go to them through a guardianship. So those are incredibly important forms, and we coordinate them all with our estate plans. We give people an attachment to file, to give to their advisor to file with the form, fidelity form. Just say, see attached, and then all the good stuff's on this attachment we give them. But even with that, should be reviewed regularly, very carefully.
I see your slide, so it's never too late for estate planning. So when should you start estate planning? Like, when do you recommend somebody see either a lawyer or a financial advisor to start estate planning?
That's a good question. I recently worked with a 28-year-old who owned his own house. He had owned his own business for a couple of years, and it was appropriate for him to do estate planning at that point. He was single, he didn't have any kids, but he wanted to make sure that if something happened to him, that his assets went to the people that he wanted them to go to. So I usually don't have clients that are that young, but usually if someone's gonna be starting to think about their estate planning, they're probably gonna be in their early to mid 30s. Maybe they're married or not. Maybe they're planning on having their first child. So that's probably, I'd say early to mid 30s is when people tend to start thinking about it, just because they're in life situations where they've maybe bought their first house, they've had a baby. They're starting to think about, well, what happens if something happens to me? I want to make sure I have a plan in place. So I'd say that's probably the age range where people start thinking about it. And then I have clients that are doing their estate plans for the first time and they're like 85 years old. So it really runs the gamut.
Yeah.
And they're like, I've been thinking about doing this for 30 years. I'm like, well, you're doing it now, so that's what matters. And it can be too late, and I think I have it here, as long as you're alive and mentally competent, it's never too late for estate planning. So having the requisite mental capacity to understand your will and your trust and the documents that you're signing is very important. So there does come a point in some people's lives where it is too late. And unfortunately, I know I've had probably 2 or 3 clients that have come to me and I just didn't feel comfortable that they understood what they were doing. So the earlier the better, of course. But yeah, as long as they understand kind of what they want and what they're doing, it is not too late. Can't I just do my estate plan myself? I've had people ask me this question in meetings when they come to me to do estate planning. So I just have an example here. So we have a married couple, Jack and Jill. They each have children from a prior relationship, no biological or adopted children together. Jack tried to save money by doing a trust online. He had multiple pieces of real estate and numerous personal items. In his trust, Jack specifically listed who he wanted to receive which assets. So like he had a watch collection, a gun collection, stamp collection, other antiques. And he wanted to give other assets to his children, his stepchildren, his friends, and some to his new wife, Jill. Unfortunately, Jack didn't complete his estate plan, so he might have had a trust, but he did not include a pour-over will, which is a special type of will, and that essentially what it does is if you have assets that are not titled to your trust when you pass away, so those assets are going through probate, this pour-over will at the end of the probate process scoops up those assets out of probate and pours them into your trust. So ultimately, they're distributed pursuant to the terms of your trust and not state law. Unfortunately, Jack did not do a pour-over will, and he didn't transfer any of his assets to his trust. So all of the assets that he owned, all the real estate, all the collections, everything was going to have to go through probate, and it was going to be distributed pursuant to New Hampshire's intestacy statute. And I guess in that instance, here we go. So in that situation, everything would have gone to, or part of it would have gone to his spouse. And depending on the amount of assets that he had, or what the value was, his children might not receive anything, and his stepchildren aren't going to receive anything under the statute either. But some questions to consider is, what if one of Jack's children is an addict or spends money as soon as he gets it? There's really nothing that can be done to stop money from going into that child's hands and spending it on more drugs or a Ferrari or whatever he feels like spending it on. What if there are people that are fighting to be the administrator? So what if Jill says, I think I need to be the administrator, but one of his adult children says, no, I should be the one to be the administrator. So now you've got people that are fighting to be responsible for the ultimate distribution of the assets when that could have been avoided. And worst of all, kind of like what I've mentioned, all of his assets have to go through probate. They're distributed pursuant to New Hampshire statute. So Jill gets, in this example, the first $100,000 of his estate plus half of anything remaining, and the rest goes to his kids. Well, what if Jack's estate is only worth $100,000? Then everything goes to Jill and nothing goes to his kids. And then when Jill passes away in the future, if she has her own estate plan, which hopefully she learned from this incident, she might be giving everything to her kids, and Jack's kids will eventually get nothing. And then the stepchildren and friends that Jack wanted to give assets to aren't going to receive anything under New Hampshire law, which is contrary to his wishes.
So this is actually a very common example.
Yeah.
Second marriages are ripe for litigation, ripe for huge disputes and terrible results. So we joke and it's not a joke, but it's, a second marriage, I should just You know, I know it's gonna be a huge amount of work and it's gonna be very costly, and it's hard to explain to people, but the cost of doing the planning is a drop in the bucket, even though it seems really expensive at the time. Because you gotta get all those things ironed out. You gotta make it clear that, you know, Jill is the executor, period. Jill's the trustee, period. Sorry, kids, you are not, or the kids are, whatever it is, but it's gotta be really clear and really carefully drafted. There is so much litigation. Families are so complicated. Litigation, unfortunately, has become big business. It's just, it's awful. So it's very, very important. And explaining to people the cost benefit is really critical. It's totally worth it.
And this is actually based on an estate administration that I was helping a client with, where she married a man, he had his own children, he did his own estate plan like this, he didn't do it correctly, and he had about 100,000 in assets, and everything went to the wife, and his two daughters didn't get anything. And there was really nothing I could do about it, even though I wish I could have. All right, so the moral of the story is you might think you're saving money by doing a DIY estate plan or not doing any planning at all. But in the end, like Ginger said, it's gonna cost way, way more and on the back end than it would be to invest right now in proper estate planning. Because you'll avoid the probate fees, the insurance bond premium that we talked about that goes along with probate, fighting among the heirs, disappointed children because they were accidentally disinherited. Most of all, stress on those who have to administer your estate. The best gift you can give your loved ones is a well-planned estate. So some people usually ask, how often am I supposed to review my estate plan? So my general rule of thumb is usually every 3 to 5 years, but you also want to consider any significant changes in your life circumstances. So that would be marriage, birth or adoption of a child, divorce, death of a child or a spouse, death of a named executor or trustee that you had named in your will or your trust, or the death of a beneficiary that you had named. If you open a new business, that's always a trigger to consider doing some estate planning, or a big change in your financial situation, such as a large inheritance, or maybe if you win the lottery or something like that. Definitely want to consider doing an estate plan or reviewing your estate plan. As we've mentioned, it's never too late to do an estate plan. Having a plan in place will help you while you're alive, as well as after you pass away, and it will also help your loved ones. You can control what happens with your assets after you pass away. You can protect your minor children if you have any. Your family members won't have as difficult of a time distributing your assets, and working with the right attorney makes the estate planning process smooth and painless. That's it.
Any questions?
Yeah.
Can you give us a range of costs, like, in order to set up your estate, you're gonna have to spend at least this amount of money. But depending on the complications of your estate, it could range up to this kind of money.
It's a hard question to answer.
Frequently asked question. So I'm gonna give you a really broad range. I would say it's kind of hard because there are a few people who have relatively simple estate plans, but I'm gonna say, you know, $3,000 to $4,000 is kind of the bottom. Second marriages, $20,000 can be. I mean, you know, my billable rate's $400 an hour, and the little intricacies of these plans, you know, sometimes you're talking about the children and who's gonna do what for an hour in the meeting. And that, you know, and so it's really worth going down every rabbit hole, because, and we call it, this is gonna sound funny, we call it putting the cuckoo hat on when we're reviewing plans, and because we review, every plan gets a second review here by another attorney. And you wanna stress test these plans, the ones that have kind of intricate and complicated stuff with, mostly with families, right? You wanna make sure, well, what if this happens? You know, what if this happens? What, and that's kind of our job. We say, what if, and sometimes we just drive our clients crazy. I'm like, I know you said this is what you want, but I have to ask you the next 6 questions because I have to have it in my notes that I asked these questions and you said, no, I'm inheriting this daughter because she didn't write me a thank you note 10 years ago. Fine, you can do whatever you want. I'm more than happy to draft that. I just wanted my notes and I want to make sure it's documented. And so when we get that call, no, she loved me. Well, I can say, no, you didn't write her that thank you note. And I asked her 6 ways from Sunday if she was really sure. And did she want to disinherit your children as well? And she said yes every time. So, you know, you have to like put that, I don't know why we call it that, but anyway, it's because there are some litigators who will throw anything up against the wall, see any argument. And some of them stick. And so we try to figure those out beforehand, before a litigator can get a hold of one of our plans and blow the whole thing up. And it's time consuming. But it's, you know, so it's kind of simple to or much more complex.
Not everything's that complex though, so it's,
No.
the majority of our plans are on the lower end,
Yeah.
probably like, at least for me, my billable rate
It's
is
a little lower
quite a
than
bit
mine.
less.
You know,
So
for a
it's
little
probably
bit like.
Like 4,000 to 6,000 for an average. No bumps in the road estate plan.
Right.
But it really, we charge our hourly rates, so it really depends on how much time we have to spend to get to the conclusion that we're looking for. Good question though.
It's tough to answer.
It's been pretty easy the last couple of years to discount the state taxes. What's your crystal ball say for what's gonna happen when the time runs out here?
Yeah, I have no idea. I, like many other people, never thought that state tax would be repealed for a year in 2010. You might remember that. No one thought that was gonna happen. And so ever since then, I have no idea. It's up to Congress and we know what's going on down there. So I heard recently, I think that there is support for continuing the tax cuts, and that's part of, I think that's what they were referring to. So 2017 tax cuts, I would think would keep the higher exemption in place, because it is a tax cut, right? But I don't know. I mean, yeah, go on.
We are looking at our clients that would fall into kind of the taxable range if the federal estate tax were to be reduced. So we're trying to do some sort of flexible planning for those clients who maybe have like 7 or 7.5 million per person, just to make sure that they have something in place if they don't come back to us right away and something happens to them and the estate tax has been reduced.
Yeah, that's a really good point. So we do what's called disclaimer planning, which is like opt-in tax planning. So they might not have, the exemption's over $13 million per person right now, but it may be halved at the end of next year. And so if somebody's got kind of in between, you know, certainly not that much, but more than half of that, then we say, well, you know, you might want to just have this tax planning in your documents so your spouse can opt in after your death. And we have a lot more flexibility. It's tricky. We've been in this now for 20 years. It's getting a little old with Congress up and down and all over the mulberry bush. And then we have these fiscal cliffs where we just don't know what's going to happen. And it always comes down to the last minute, December 18th or something, or December 20th or December, or after. I think 2012, I think they did it after the new year because we were literally living at the office and it lasted all the way through the end of the year because we had no idea what was going to happen. And everybody wanted to take that money out from their mattress and give it away. You know, so it's a lot of work. It's hard. Anything else?
Yeah.
What are the sort of circumstances where you're recommending like an irrevocable trust? Is that primarily for kind of like more elderly clients where maybe they're gonna be thinking that they potentially might go into a nursing home and they wanna kind of keep their residence for their children? Or are there other circumstances that pop up where you're thinking, you know, an irrevocable trust might be better for this client? What type of circumstances where that is?
So we don't really do a lot of Medicaid planning, which is kind of what you're talking about with doing irrevocable trusts and trying to plan for your eventual stay at a nursing home. We usually refer that kind of work out to people that really stay on top of the Medicaid rules. But we have quite a few wealthy clients that recently established irrevocable trusts for the benefit of their grandchildren, so they can make annual gifts to their grandkids, which will slowly try to decrease the amount of wealth that they have while they're giving gifts that are not gonna be taxable. So usually is for wealthier clients where we would do an irrevocable trust, because it is quite a bit of work. So it does cost a decent amount, but for their goals, it makes sense.
Yeah, there's a whole lot of uses for irrevocable trust. That's probably the most common that we've done a lot of recently. Anytime you can shift wealth from somebody who's gonna be in a taxable situation at their death, and the federal estate tax is 40% flat rate. So if you're over that amount, if you're over whatever the exemption is, it's 40% of the remainder. And you pay it, your tax, so if your estate is $15 million or $20 million, you're taxed on the difference between, say, 13 million and, you're taxed on that 7 million roughly. And then you pay the tax out of your estate. So you're paying tax, you're paying the 40% out of money that was just taxed at 40%. If you give it away during your life, you're not taxed on that money. It's kind of a funny thing, but people, so it's really good if people can afford to, give away money, and giving it away can be to a 529 plan for education for their grandchildren or children. It can be putting it in one of these trusts for grandchildren, and it shifts the appreciation. So if the client lives another 30 years and they've shifted $300,000 over a few years to a trust for 3 grandchildren, roughly $900,000, and they live another 30 years, that $900,000 could be $3 million, $4 million, $5 million, and whatever it is, they've shifted all that wealth down. So that's a lot of the reason we do tax planning trusts and gifting to irrevocable trusts for the benefit of minor grandchildren or whoever. So.
Any other questions? All right, great. Thank you for attending.
Yeah.